a songwriter's agreement could go on for a number of pages, but there are certain terms that I like to include that I find most important. The division of income is more or less the division of ownership in the copyright. 75, 25, 50, 50, where is it? It's not a hard and fast rule. I think that if you have a lyricist and you have a composer, it's 50-50, but you can make the argument that says I want 66.6 and the other party gets 33.3. It's whatever you write in the contract, that stands. What kind of rights do the joint authors or the co-authors have to exploit this work? Do they have to get approval of all the other co-authors before they do it free or exclusively? Well, they would have to do it exclusively, wouldn't they? Even under a joint work without a contract. But we don't want them going in and licensing this out for free when we can perhaps earn some income from this other party by using it at a fee. This is something that I particularly like to put in, and that is, even though this is considered a joint work, if I'm Philip Glass, I can still take my instrumentals and bring them to another party, and I do not have to account to you if I use my individual contribution to it. And this is pretty crucial. If you write lyrics and somebody else wants to re-record it, you only want them to use the lyric part of it, while the composer can be more or less locked out of that because of this agreement. I think this is a beneficial thing as long as you're the lyricist. And then how about credit? When we are going to exploit and license this copyright, what kind of credit should we have? What is it going to look like? Produced by, sung by, lyrics by, melody by. You know, we want to put that in there to make sure that it's accurate.